हेलो एवरीवन। हाई कोर्ट ऑफ गुजरात में लीगल असिस्टेंट की वैकेंसी आई हुई है। 15th ऑफ जून को उसका एग्ज़ाम है। यहाँ पे मैं प्रीवियस ईयर क्वेश्चन पेपर आपको बता रहा हूँ और नेक्स्ट वीडियो में आंसर कीज के साथ मैं यहाँ पे डिस्कस करूँगा। तो प्रीवियस ईयर पेपर्स अगर किसी को सॉल्व करना है या अटेम्प्ट करना है तो ये वीडियो उनके लिए है। यहाँ पे आप वीडियो को पॉज करके भी आंसर कर सकते हैं। नेक्स्ट वीडियो में मैं आंसर कीज के साथ इसको डिस्कस करने वाला हूँ। सो फर्स्ट क्वेश्चन इज द वर्ड्स sovereign, socialist, secular, democratic, republic in the preamble to the Constitution of India were substituted by the dash for the words sovereign, democratic, republic. Option A, Constitution under the 42nd Amendment Act 1976, Constitution under 43rd Amendment Act 1976, Constitution under 7th Amendment Act 1956 and Constitution under 35th Amendment Act 1974. दूसरा क्वेश्चन, द स्टेट shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. In which of these articles of the Constitution of India do you find it? Option A, Article 12, option B, Article 13, option C, Article 14, and option D, Article 19. तीसरा क्वेश्चन, विच ऑफ द स्टेटमेंट गिवन इज और आर ट्रू रिगार्डिंग आर्टिकल 18, द एबोल्यूशन ऑफ टाइटल्स अंडर द कॉन्स्टिट्यूशन ऑफ इंडिया? ऑप्शन ए, no title not being a military or academic distinction shall be conferred by the state. Option B, no citizen of India shall accept any title from any foreign state. Option C, no person holding any office of profit or trust under the state shall, without the consent of the President, accept any present, emolument, or office of any kind from or under any foreign state. And option D, all of this option. Question 4. By the Constitution 86th Amendment Act 2002, which of these fundamental rights was inserted? Option A, right to equality. Option B, right to constitutional remedies. Option C, right to education. And option D, none of these options. Question 5. It has been settled by a series of decisions of this court that the word life in Article 21 of the Constitution means a life of dignity and not just an animal life. In which of these cases did the Honorable Supreme Court observe it? Option A, Buddhadev Karmaskar versus State of West Bengal. Option B, State of Tamil Nadu versus K. Shyam Sundar. Option C, Dr. Subramaniam Swamy versus State of Tamil Nadu. And option D, Manish Goyal versus Rohini Goyal. Question number 6. Part 4A pertaining to the fundamental duties was inserted in the Constitution of India by way of the option A, Constitution under 46th Amendment Act 1982, option B, Constitution under 42nd Amendment Act 1976, option C, Constitution under 32nd Amendment Act 1973, and option D, Constitution 40th Amendment Act 1976. Question 7. In which of these cases did the Honorable Supreme Court observe that Article 141 uses the phrase law declared by the Supreme Court? It means law made while interpreting the statutes of the Constitution. Such judicial lawmaking is part of the judicial process under option A, Sara India Real Estate Corporation Limited and others versus Securities and Exchange Board of India and others. Option B, Academy of Nutrition Improvement versus Union of India. Option C, Narayan Dutt versus State of Punjab. And option D, DC Wadhwa versus State of Bihar. Question 8. The provisions contained in Part 4 pertaining to the directive principles of state policy shall option A be enforceable by any court, option B not be enforceable by any court, option C be enforceable only by the Supreme Court, option D be enforceable only by the High Court. Question 9. Which of these rights is or are not the fundamental rights enshrined in Part 3 of the Constitution of India? Option A. Cultural and educational rights. Option B. Right against exploitation. Option C. Right to freedom of religion. And option D. None of this option. Question number 10. Under Article 299 of the Constitution of India, all contracts made in the exercise of the executive power of the Union shall be expressed to be made by the option A. Prime Minister, option B. President, option C. Chief Minister, and option D. Attorney General. Question 11. Which of these described persons fall within the meaning of public officer under the Code of Civil Procedure 1908? Option A. Every officer in the service of the government for the performance of any public duty. Option B. Every judge. Option C. Every member of an All India service. And option D. All of this option. Question number 12. In the lights of the provision of Section 10 of the Civil Procedure Code 1908, the pendency of a suit in a foreign court dash the courts in India from trying a suit founded on the same cause of action. Option A precludes. Option B does not preclude. Option C bars. And option D none of this option. Question number 13. A. Residing in Delhi publishes in Kolkata statements defamatory of B. B. May sue A. Option A. Either in Kolkata or in Delhi. Option B. At anywhere in India. Option C. Only in Kolkata. And option D. None of these options. Question number 14. Under the Code of Civil Procedure 1908, where the court reformulates the terms of a possible settlement, it may refer the same for option A. Arbitration or mediation, option B. Conciliation, option C. Judicial settlement, including settlement through Lok Adalat, and option D. All of these options. Question number 15. If a party has obtained an order for leave to amend, but no time is limited for carrying out the amendment by that order, he will have to carry out such amendment within dash days from the date of the order. Option A 7, option B 10, option C 12, and option D 14. Question number 16. Subject to the provisions of Section 21 of the Limitation Act 1963, the proceedings as against any person added as defendant shall be deemed to have begun only option A on the plain being amended, option B on the service of the summons, option C on the passing of the order by the court, and option D none of these options. Question number 17. In a suit before the civil court, admissions of fact have been made in the pleading. Choose the correct option. Option A. The court shall not rely upon such admissions and should carry on with the full-fledged trial. Option B. The court may, at any stage of the suit, upon the application of any party or of its own motion and without waiting for the determination of any other questions between the parties, make such order or give such judgment as it may think fit, having regard to such admissions. Option C. Order 14 of the Code 1908 states that the court shall pronounce judgment on all issues and therefore at no cost the court shall dispose of the suit on such admissions. And option D. None of these options. Question number 18. Where the plaintiff is a minor or other person to whom the provisions contained in Rule 1 to 14 of Order 32 of the Code of Civil Procedure 1908 extend, what is the correct position of law as regards the abandonment of the suit or part of the claim? Option A. At any time after the institution of a suit, the plaintiff may abandon his suit or abandon a part of his claim as against all or any of the defendant. Option B. At any time after the institution of a suit, the plaintiff may abandon only a part of his claim as against all or any of the defendant. Option C. Neither the suit nor any part of the claim shall be abandoned without the leave of the court. And option D. None of these options. Question 19. Defendant in a regular civil suit has filed an application under Order 7, Rule 11 of the Code of Civil Procedure 1908 for rejection of the plaint. Civil Court, after hearing the parties, has allowed the application. Where would the appeal under the law lie if the party aggrieved wants to challenge the said order? Option A. Before the district court under Order 43 of CPC 1908. Option B. Before the district court under Order 41 of CPC 1908. Option C. Before the High Court under Article 227 of the Constitution of India. And option D. All of these options. Question number 20. There are dash sections and dash orders including repealed in the Code of Civil Procedure 1908. Option A 156 49. Option B 156 50. Option C 157 53. And option D 158 51. Question number 21. Where a police officer arrests without warrant any person other than a person accused of a non bailable offense, he shall, option A, inform the person arrested that he is entitled to be released on bail and that he may arrange for sureties on his behalf. Option B, inform the person arrested that he will not be released on bail. Option C. Inform the person arrested that he will be released on bail only by the order of the High Court. And option D. None of this option. Question number 22. A warrant of arrest is directed to one or more police officers, but no police officer is immediately available and immediate execution of the warrant is necessary. What is the legal position under the Code of Criminal Procedure 1973? Option A. The court issuing such a warrant may direct it only to police officers of another district and they shall have to execute the same. Option B. The court issuing such a warrant may direct it to any other person or persons and such person or persons shall execute the same. Option C. The court issuing such a warrant may wait till those police officers are available and then direct it to them for execution. And option D. All of these options. Question number 23. How shall the proclamation for person absconding be published under section 82 of the Code of Criminal Procedure 1973? Option A. By affixing it to some conspicuous part of the house in which such person ordinarily resides. Option B. By affixing a copy thereof to some conspicuous part of the courthouse. Option C. By publicly reading it in some conspicuous place of the town or village in which such person ordinarily resides. And option D. All of the above. all of these options. Question number 24. If, after consideration of the record of the case before the Court of Sessions, the documents submitted therewith, and hearing the submissions of the accused and the prosecution, the judge is of the opinion that there is ground for presuming that the accused has committed an offence exclusively triable by the court, he dash option A shall pass a judgment of conviction and then hear the accused on the quantum of punishment. Option B shall discharge the accused and record his reasons for doing so. Option C shall frame in writing a charge against the accused. And option D, none of these options. Question number 25. The power of any court to summon material witness or examine person present or re-examine any witness already examined is found in which of the section of the Code of Criminal Procedure 1973? Option A 309, option B section 310, option C section 311, option D section 312. Question number 26. Choose the correct statement in light of the provisions streaming through section 313 of the Code of Criminal Procedure 1973. Option A. The accused shall not render himself liable to punishment by refusing to answer the questions put to him or by giving false answer to them. Option B. The court may take help of prosecutor and defense counsel in preparing relevant questions which are to be put to the accused. Option C. The court may permit filing of written statement by the accused as sufficient compliance of section 313. And option D. All of these options. Question number 27. In which of these cases did the Honorable Supreme Court conclude that first, police has the statutory rights and duties under the relevant provisions under the Code of Criminal Procedure contained in Chapter 14 of the Code to investigate into a cognizable offence? Secondly, courts would not thwart any investigation into the cognizable offence. Third, it is only in cases where no cognizable offense or offense of any kind is disclosed in the first information report that the court will not permit an investigation to go on. Option A, Ms. Neharika Infrastructure Private Limited versus State of Maharashtra and others. Option B, Lalita Kumari versus Government of UP and others. Option C, Sri Ram Naresh Yadav versus the state of Madhya Pradesh. And option D, Rajneesh versus Neha and others. Question number 28. In which of these cases did the Honorable Supreme Court, while discussing the jurisdiction of the High Court under Section 397 of CRPC, observe thus: as a caveat, it may be stated that the High Court, while exercising its aforestated jurisdiction, ought to be circumspect, albeit there should be interference, may be in exceptional cases, failing which there is likelihood of serious prejudice to the rights of a citizen. For example, when the content of a complaint or other purported material on record is brazen apart to prosecute an innocent person, it becomes imperative upon the court to prevent the abuse of process of law. Has been given under option A, Sanjay Kumar Rai versus State of Uttar Pradesh and others. Option B, CBI versus Mustafa Ahmed Dosa. Option C, Nani Gopal Biswas versus the Municipality of Havra. And option D, Jagriti Devi versus State of Himachal Pradesh. Question number 29. Choose the correct statement from the options given in the light of the provisions flowing through Section 6 of the Specific Relief Act 1963 pertaining to the suit by person dispossessed of immovable property. Option A, if any person is dispossessed without his consent of immovable property otherwise than in due course of law, he or any person claiming through him may, by suit, recover possession thereof, notwithstanding any other title that may be set up in such suit. Option B, no suit under Section 6 of the said Act 1963 shall be brought against the government. Option C, no appeal shall lie from any order or decree passed in any suit instituted under Section 6 of the said Act 1963. And option D, all of these options. Question 30. Under Section 11 of the Specific Relief Act 1963, what would be the legal position if a contract is made by a trustee in excess of his powers or in breach of trust? Option A, contract cannot be specifically enforced. Option B, contract can be specifically enforced. Option C, part of the contract can be specifically enforced. And option D, both the options B and C. Question 31. Section 14 of the Specific Relief Act 1963, which relates to the contracts not specifically enforceable, was substituted by which of the Amendment Act? Option A, the Specific Relief Amendment Act 2014. Option B, the Specific Relief Amendment Act 2016. Option C, the Specific Relief Amendment Act 2018. And option D, the Specific Relief Amendment Act 2019. Question number 32. Notwithstanding anything contained in subsection 1 of section 27 of the Specific Relief Act 1963, the court may refuse to rescind the contract by option A, where the contract is unlawful for the causes not apparent on its face and the defendant is more to blame than the plaintiff. Option B, where the plaintiff has expressly or impliedly ratified the contract. Option C, where the contract is voidable or terminable by the plaintiff. And option D, none of this option. Question number 33. In one suit, an injunction has been sought to restrain the defendant from applying to any legislative body. Choose the correct option. Option A, an injunction can be granted. Option B, only perpetual injunction can be granted. Option C, only mandatory injunction can be granted. And option D, an injunction cannot be granted. Question number 34. Which of these are not included in the term trustee under the Limitation Act 1963? Option A, a person in wrongful possession without title. Option B, a mortgagee remaining in possession after the mortgage has been satisfied. Option C, Benamdar. And option D, all of these options. Question number 35. In one case, there is delay in preferring an appeal. The appellant states in the delay condemn application that he was misled by the judgment of the High Court in ascertaining or computing the prescribed period. What is the legal position in the light of Section 5 of the Limitation Act 1963? Option A may be a sufficient cause within the meaning of Section 5 of the said Act 1963. Option B, this cannot be a sufficient cause to condemn the delay. Option C, this is abuse of the process of the court. And option D, both the option B and C. Question number 36. The period of limitation for preferring an appeal to the High Court from any decree or order under the Code of Civil Procedure 1908 is dash days. Option A 30, option B 60, option C 90 and option D 120. Question number 37. The period of limitation for preferring an application for an order to set aside an abatement under the Code of Civil Procedure 1908 is dash days. Option A 30, option B 60, option C 90, and option D 120. Question number 38. Whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person is said to do that thing. Option A with coercion, option B dishonestly, option C with undue influence, and option D none of these options. Question number 39. Under the scheme of Indian Penal Code 1860, nothing is an offence which is done by a child under dash years of age. Option A 7, option B 9, option C 12, and option D 16. Question number 40. Z is carried off by a tiger. A fires at the tiger, knowing it to be likely that the shot may kill Z, but not intending to kill Z, and in good faith intending Z's benefit. His shot gives Z a mortal wound. Choose the correct option. Option A. A has committed the offense of murder. Option B. A has committed the offense of attempt to murder. Option C. A has committed the offense of grievous hurt. And option D. A has committed no offense. Question 41. Under the Indian Penal Code 1860, whoever is a member of an unlawful assembly shall be punished with imprisonment of either description for a term which may extend to option A 3 years or with fine or with both, option B 6 months or with fine or with both, option C 2 years or with fine or with both, and option D 1 year or with fine or with both. Question number 42. The offense of obstructing public servant in discharge of public function is classified as one which is option A compoundable, option B non compoundable, option C cognizable, and option D non bailable. Question number 43. The offense of culpable homicide not amounting to murder is classified as one, which is option A cognizable, bailable, and compoundable, option B non cognizable, non bailable, and compoundable, option C non cognizable, non bailable, and non compoundable, and option D cognizable, non bailable, and non compoundable. Question number 44. In the classification of offences under the first schedule of CRPC 1973, the offence thug is classified as one which is option A tribal by the magistrate of first class, option B tribal by any magistrate, option C tribal by court of session, and option D tribal by the district magistrate. Question number 45. The offence of voyeurism in section 354 subclause C of the Indian Penal Code 1860 was inserted by which of these amendment acts? Option A. The Criminal Law Amendment Act 2013. Option B. The Criminal Law Amendment Act 2018. Option C. The Criminal Law Amendment Act 2005. And option D. The Criminal Law Amendment Act 2005. Question number 46. Section 376 AB was inserted in the Indian Penal Code 1860, which states that whoever commits rape on a woman under dash of age shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life, which shall mean imprisonment for remainder of that person's natural life, and with fine or with death. Option A 9 years, option B 10 years, option C 12 years, and option D 16 years. Question number 47. A proposes by a letter sent by post to sell his house to B. B accepts the proposal by a letter sent by post. When may A revoke his proposal? Option A at any point of time, Option B, at any time, before or at the moment when B posts his letter of acceptance but not afterwards. Option C, at the time when A, after receiving the letter of acceptance from B, finds that the sale price is inadequate. And option D, none of this option. Question number 48. A agrees with B to discover treasure by magic. Option A, the agreement is voidable. Option B, the agreement is void. Option C, the agreement is partly voidable. And option D, none of this option. Question number 49. A becomes surety to C for B's conduct as manager in C's bank. Afterwards, B and C contract without A's consent that B's salary shall be raised and that he shall become liable for one fourth of the losses on overdrafts. B allows a customer to overdraw and the bank loses a sum of money. Option A has to make good the loss caused to the bank. Option B, A is bound by the contract of suretyship, irrespective of the fact whether his subsequent consent was obtained or not. Option C, A is discharged from his suretyship by the variance made without his consent and is not liable to make good this loss. And option D, both the options A and B. Question number 50. As regards creation of agency, what is the correct legal position for consideration? Option A. No consideration is necessary to create an agency. Option B. No agency can be created without consideration. Option C. Consideration is an essential part for creating an agency. And option D. Both the options B and C. Question number 51. A gives authority to B to sell A's land and to pay himself out of the proceeds the debts due to him from A. What is the law regarding revoking of the authority and its termination in this case? Option A. In the given case, A can revoke authority and terminate the agency. Option B. In the given case, A cannot revoke the authority nor can it be terminated by his insanity or death. Option C. In the given case, A can partly revoke this authority. And option D. Both the options A and C. Question number 52. Property of any kind may be transferred except as otherwise provided by the Transfer of the Property Act 1882 or by any other law for the time being in force. In this context, choose the correct statement from the given option. Option a mere right to sue cannot be transferred. Option B, an easement cannot be transferred apart from the dominant heritage. Option C, stipend allowed to military cannot be transferred. And option D, all of this option. Question number 53. The provisions regarding rule against perpetuity are found in which of the sections of the Transfer of Property Act 1882? Option A, Section 10. Option B, Section 12. Option C, Section 14. And option D, Section 15. Section 54. Transfer of ownership in exchange for a price paid or promised or part paid and part promised is called option A, part performance, option B, sale, option C, license, and option D, gift. Question number 55. The question is whether a particular letter was dispatched and whether it reached A. Which of the statement is or are relevant facts? Option A, that it was the ordinary course of business for all letters put in a certain place to be carried to the post. Option B, that particular letter was put in that certain place. Option C, that it was posted in due course and was not returned. And option D, all of these options. Question number 56. Which of this is or are facts which the court shall take judicial note of? Option A, the rule of the road. Option B, all laws in force in the territory of India. Option C, articles of war for the Indian Army. And option D, all of the options. Question number 57. Primary evidence means option A, copies made from the original by mechanical process. Option B, copies made from or compared with the original. Option C, the document itself produced for the inspection of the court. And option D, all of these options. Question number 58. The court's power to make comparison of disputed and admitted signature for just conclusion is found in which of the section of the Evidence Act 1872? Option A, Section 72. Option B, Section 73. Option C, Section 74. And option D, Section 75. Question number 59. Which of this presumption cannot be made by the court while dealing with the documents 30 years old produced from any custody which the court in the particular case considers proper? Option A, presumption that the signature and every other part of such document which purports to be in the handwriting of any particular person is in that person's handwriting. Option B, presumption that in case of a document executed or attested that it was duly executed and attested by the persons by whom it purports to be executed and attested. Option C, presumption that content of the same are true. And option D, none of this option. Question number 60. A desires a court to give judgment that he is entitled to certain land in the possession of B by reasons of fact which he asserts and which B denies to be true. Choose the correct option as regards the burden of proof. Option A and B both shall have to prove the facts asserted by them. Option B, A must prove the existence of those facts. Option C, B must prove that A is not entitled to the particular land in his possession. And option D, none of these options. Question number 61. The examination of a witness subsequent to the cross examination by the party who called him shall be called his option A, rejoinder, option B, cross examination, option C, re examination, and option D, none of these options. Question number 62. The court may, in its discretion, permit the person who calls a witness to put any question to him which might be put in cross examination by the adverse party. Where do you find it in the Indian Evidence Act 1872? Option A, Section 137. Option B, Section 141. Option C, Section 142. And option D, Section 154. Question number 63. As regards the number of witnesses, dash of witnesses shall in any case be required for the proof of any fact. Option A, minimum 2 number. Option B, minimum 4 number. Option C, minimum 6 number. And option D, no particular number. Question number 64. In one case, the existence, condition, or contents of the original have been proved to be admitted in writing by the person against whom it is proved. Option A, irrespective of the facts given, primary evidence is required to be given by producing the original document itself, otherwise, the case would fail. Option B, in peculiar facts given, secondary evidence may be given of the existence, condition, or content of such a document. Option C, law recognizes primary evidence to be given at any cost. And option D, both option A and C. Question number 65. The period of limitation in an appeal from a sentence of death passed by court of session or by a high court in the exercise of its original criminal jurisdiction under the Code of Criminal Procedure shall be dash days from the date of sentence. Option A 30, option B 60, option C 90, option D 180. Question number 66. The period of limitation is preferring an application for the enforcement of a decree granting a mandatory injunction shall be dash from the date of the decree or where a date is fixed for performance. Such date. Option A 60 days, option B 180 days, option C 3 years, and option D 12 years. Question 67. Where issues both of law and fact arise in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only, it may try that issue first if it relates to option A, the conduct and character of the party, option B, the jurisdiction of the court or a bar to the suit created by any law for the time being in force, option C, essential facts hitting the root of the case, and option D, none of these options. Question number 68. Two or more persons are said to dash when they agree upon the same thing in the same sense. Option A, rebuff. Option B, spurn. Option C, consent. And option D, none of these options. Question number 69. Where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. Where do you find this provision in the Code of Civil Procedure 1908? Option A, Order 12, Rule 2, Subclause 2. Option B, Order 1, Rule 2, Subclause 2. Option C, Order 2, Rule 2, Subclause 2. And option D, Order 11, Rule 2, Subclause 2. Question number 70. The period of limitation for preferring an application for which no period of limitation is provided elsewhere in the third division of the schedule appended to the Limitation Act 1963 is option A 12 years, option B 3 years, option C 180 days, and option D 60 days. क्वेश्चन नंबर 71 से आपके जीके मैथ्स रीजनिंग के क्वेश्चन स्टार्ट हो रहे हैं. क्वेश्चन नंबर 71. What lies beyond the sun, the moon and stars is a three-dimensional area called? Option A, the Milky Way. Option B, black hole. Option C, distant quasars. And option D, space. Question number 72. The dash once said history repeats itself. Option A, German philosopher Hegel. Option B, American philosopher Dewey. Option C, Indian philosopher Shankara. And option D, Australian philosopher Wittgenstein. Question number 73. The years which began with the birth of Jesus Christ is known as option A, prehistoric, option B, Anno Domini, option C, before Christ, and option D, none of these options. Question 74. The dash is an important landmark in the history of India which occurred during the Governor Generalship of Lord Canning. Option A, Satyagraha movement. Option B, Dandi March. Option C, Bardoli movement. And option D, Revolt of 1857. Question 75. The Jallianwala Bagh massacre took place on 13/4/1917, option B 13/4/1918, option C 13/4/1919, and option D 13/4/1920. Question number 76. The famous site of Brindavan Gardens is located in which of the state? Option A Karnataka, option B Uttar Pradesh, option C Rajasthan, and option D Himachal Pradesh. Question number 77. To every action, there is an equal and opposite reaction. Option A, this is Newton's first law of motion. Option B, this is Newton's second law of motion. Option C, this is Newton's third law of motion. And option D, this is Kepler's law of planetary motion. Question number 78. The largest gland of the human body, weighing approximately 1500 gram, is option A, lymph, option B, liver, option C, pancreas, and option D, ovaries. Question number 79. Dash was the first Deputy Prime Minister of India. Option A, Morarji Bhai Desai. Option B, Dr. Zakir Hussain. Option C, Dr. S. Radhakrishnan. And option D, Sardar Vallabhbhai Patel. Question number 80. The newspaper Daily Mirror is published in option A, London, option B, Paris, option C, Mumbai, and option D, Washington. Question number 81. Choose the most appropriate preposition to fill in the blanks in this sentence. We here dash it, dash our meeting. Option A, off, during. Option B, at, through. Option C, at, during. And option D, off, through. Question number 82. Give the meaning of the idiom, a big shot. Option A, excellent target. Option B, nice shot. Option C, important person. And option D, white collar crime. Question number 83. Complete the sentence. Walking at 3 o'clock, I heard the dash of thunder. Option A, croak. Option B, rumble. Option C, clank. And option D, ripple. Question number 84. When something is added either in the beginning or in the end, words formed in this way are option A, primary derivatives, option B, secondary derivatives, option C, demonstrative sources, and option D, none of this option. Question number 85. Verb from the noun glory will be option A, englory, option B, glory, option C, glorious, and option D, glorify. Question number 86. This popular line is from which of this Shakespeare's play? Friends, Romans, countrymen. Lend me your ears. Option A, Romeo and Juliet. Option B, Julius Caesar. Option C, Hamlet. And option D, Two Gentlemen of Verona. Question number 87. Dash won the Sahitya Academy Award for writing in English in the year 2019 for the book An Era of Darkness, The British Empire in India. Option A, Mamang Dai. Option B, Anish Salim. Option C, Adil Jusawala. And option D, Shashi Tharoor. Question number 88. The book Gandhi, A Life has been written by option A, Sri Jawaharlal Nehru, option B, Sri S.C. Bose, option C, Sri Narayan, option D, Sri Krishna Kriplani. Question 89. Which book is translated and edited by J. A. B. Van Buchanan? Option A, the Mahabharata. Option B, the Ramayana. Option C, the Shiv Purana. And option D, the Vishnu Purana. Question number 90. A sentence which expresses strong feeling is known as option A, assertive sentence, option B, interrogative sentence, option C, negative sentence, and option D, exclamatory sentence. Question number 91. Give the full name of OMR. Option A, original mark reader. Option B, optical mark reader. Option C, optical make reader. And option D, original mark reactor. Question number 92. An operating system is an interface between the dash and the computer hardware. Option A, user. Option B, software. Option C, data. And option D, none of this. Question 93. NTFS is the default file system in option A, Ubuntu, option B, Microsoft Windows, option C, Chrome OS, and option D, SUSE. Question number 94. Hypertext was first coined by dash in 1960s. Option A, Charles Babbage. Option B, Tim Berners-Lee. Option C, Ted Nelson. And option D, Barbara Liskov. Question number 95. Speed of communication over a data channel is measured in A, baud, B, volt, C, Kelvin, and D, Pascal. Question number 96. What does LCD in display device stand for? Option A, liquid crayon display. B, liquid cathode display. C, liquid carbon display. And D, liquid crystal display. Question number 97. Find the solution to 10, 26, 50, 80, 82. You have to solve this. Option A, 100. B, 122. C, 144. D, 164. Question 98. How many letters are there between the 18th letter from left and 7th letter from left in the English alphabet? Option A, 10. B, 12. C, 1. And D, 11. Question number 9. If the sign plus and minus are interchanged and the number 5 and 8 are interchanged, which of these options is correct? Option A, 82 minus 35 plus 55 is equal to 2. Option B, 52 minus 35 plus 55 is equal to 72. Option C, 85 minus 38 plus 85 is equal to 132. And option D, 82 minus 35 plus 55 is equal to 102. And question number 100. Arrange these words in their ascending order: millennial, diamond jubilee, silver jubilee, century and golden jubilee. और आपके ऑप्शंस यहाँ पे दिए गए: ए 23541, ऑप्शन बी 25314, ऑप्शन सी 35241 एंड ऑप्शन डी 23514. तो आप ये वीडियो को पॉज करके भी इसके आंसर्स कर सकते हैं. क्वेश्चन नंबर 70 तक लॉ के सारे क्वेश्चंस पूछे गए एंड आफ्टर क्वेश्चन नंबर 70 इंग्लिश, मैथ्स, रीजनिंग, कंप्यूटर एंड जीके क्वेश्चंस पूछे गए. ये प्रीवियस ईयर का क्वेश्चन पेपर है फॉर लीगल असिस्टेंट्स ऑफ गुजरात हाई कोर्ट. इन द नेक्स्ट वीडियो मैं इसके सॉल्यूशंस के साथ वीडियो अपलोड कर दूंगा. थैंक यू.